Hello, I'm Edgardo Villanueva, President of EMSI Consulting. I want to thank you for tuning in to this video presentation today about a very important subject. I'm very glad to have with me today Alan Kaplan, who is a principal of the law firm of Masuda Funai in the Chicago offices. Masuda Funai is not only a national firm, but it's an international firm. Alan is an expert in employment and labor relations law on behalf of management, and he and I have had a chance to work on many cases over the years. Today we want to talk about a particularly sensitive subject, or potentially sensitive subject, and that deals with how to handle properly the termination of an employee who falls under one of the EEOC's protected classes. So Alan, thank you very much for your time, and I want to start by kind of giving an overview. Over the years, most people are familiar with the fact that the EEOC has established protected classes to prevent discrimination on the basis of age or race or religion or sex. But we know that this is continuously evolving. So tell us, in addition to the quote, traditional protected classes, what new categories are you seeing that the EEOC is now expanding and covering under their jurisdiction?
Yeah, thank you very much for inviting me. I would say that there's several places where the EEOC is trying to expand the coverage of their laws of Title VII. First, there's a new law called GINA, which is about genetic information. Okay. So that's issues about family medical history or genetic testing. Decisions based upon those issues are now unlawful. Also, the EEOC is trying to expand the area of disability protection under the American with Disabilities Act to cover intellectual disabilities, for example. The EEOC is also trying to expand its jurisdiction for convictions. What questions can be asked during interviews and on employment applications on convictions, and whether or not convictions and asking those questions is a violation of national origin or race discrimination. What's very important is what's happening at the state and local level. So, for example, gays and lesbians are protected by state law and many city laws where they're at the moment not protected by federal law. Even in Illinois, lawful activities such as smoking is a protected classification. So companies have to be aware not only of the protections of federal law, but of state and local law when they make decisions.
Wow. It certainly creates additional challenges. Let me ask you also, in dealing with the termination of this kind of someone who is under a protected class, what additional steps or considerations do employers need to take into account that they might not in what we might refer to as more traditional situations involving a termination of an employee?
There's a two-step process, due diligence and due process. Due diligence is the process of figuring out what the risk management is. And you've already covered part of the major risk, which is discrimination law. There's many other types of risks, contract law, tort law under state law, other federal laws. So due process is determining what the risks are. There's two basic types of evidence under discrimination law, direct evidence and circumstantial evidence. Direct evidence are specific statements by supervisors, so that's part of due diligence, or statements made by a supervisor about that employee's national origin or religion. Circumstantial evidence, was that employee treated the same as other employees?
I see. So again, posing the additional burden on employers to be sure that they've covered all of these steps. And if a termination of this nature is mishandled, what are the potential liabilities and monetary damages that a company could face?
The most embarrassing remedy that a court can award an employee who was terminated is reinstatement. For example, the bellboy of a hotel who was reinstated by the court and walked into the hotel to see all of his former employees saying, "I'm back." He stayed for 2 days and then quit, but he made his message. But besides that reinstatement, there's plenty of monetary damages. Back pay, the amount of money the employee would have earned if he had not been terminated. front pay for the period of time the employee will not be able to work, compensatory damages for medical expenses the employee may have suffered, punitive damages to punish the company, attorney's fees of the employee, as well as attorney's fees for the company. Therefore, one decision can cost a company $500,000. It's really worth talking to an attorney for 15 minutes or to a consultant for 15 minutes to save that company $500,000 to do the due diligence, to do the due process.
I agree very much, yeah. One other area that I think is of interest and to clear up a confusion, in unionized companies, it's pretty common knowledge that if an employee is called into a disciplinary or termination session, that he can demand to have a union representative there to witness or to support him or to help him present his case. There's a confusion about whether or not employees in non-unionized companies have that same right to demand someone to be at their disciplinary session. And typically the confusion comes with a misunderstanding of what is commonly known as the Weingarten rights. Can you clarify that for us, please?
Yeah, at the moment, employees in a non-unionized environment do not have Weingarten rights.
I see.
They do not have the right to have a representative present during a meeting with a supervisor in which they fear that discipline may result. At one time, they did have that right. But the membership of the National Labor Relations Board in Washington changed, and that right was ended. There's now a new board in place, and that board may well give those rights to non-unionized workers. There may be many other rights that non-unionized workers have. And the NLRB over the last 5 years have really expanded the role of the NLRB for non-unionized companies.
Especially in these kinds of cases. Yes. So you've covered some, necessary steps in terms of the due diligence and so forth, but what other specific steps could you recommend that employers and HR professionals take to prevent potentially costly litigation when mishandling one of these types of cases?
Well, besides due diligence, there's the process of due process. And due process is the way the decision is made and the way the decision is implemented. So when we come to the way the decision is made, every company should audit their process first. Determine how are decisions made now about termination, about employment decisions. Are decisions made by first-line supervisors on oral warnings without the input of the human resource professional or the CFO or the president? Are termination decisions made by certain persons? Should they be made by certain persons? I believe best practices dictates that HR professionals and higher level executives be involved in termination decisions. So how is the decision made? What type of internal documentation is created? That's key to due process.
Very important information, sure. And in your practice, I know I've seen it, but over your many years of practice, what types of mistakes do you see typically made by employers when handling this type of sensitive type of termination?
The biggest mistake is the statement of the reason for the termination. This goes to due process. Was the reason discussed by the supervisors in emails, in internal memos? Yes. Is that reason or reasons the same as given to the employee? Is it the same given by the payroll clerk, perhaps, to the unemployment compensation office? And the payroll clerk doesn't talk to the human resource professional who gave that reason. And is that the same reason given to the government? When there's different reasons given for termination, a court or jury will think that the company is hiding the real reason. And that real reason is an unlawful reason.
Inconsistencies will always come back to hurt you, right?
Absolutely.
Especially in the paperwork, yeah. Well, Alan, all of this is very, very important advice, and I guess if I could ask you to kind of summarize or wrap it up, do you have any other advice for those viewing this presentation today when it comes to these particularly sensitive and potentially legally and monetarily challenging situations?
I always say that it's the way a termination is conducted as opposed to the fact of termination that leads to a lawsuit. Therefore, part of due process is understanding and making decisions about the implementation of the termination decision. The company and the employee being terminated wants a smooth transition. How best to make that smooth transition? Should there be a witness at the termination interview? Are we worried about violence in the workplace? Should severance be given to the employee? Should there be outplacement? Will the employee be given the so-called perp walk out of the office so they don't have a chance to see their friends and say goodbye to their friends? This is a very important part of due process. This is part of the auditing process that HR professionals should conduct every year as to how terminations are decided and implemented. And then based upon that audit, training should be conducted of all levels of supervision and decision making to make sure that the company will be protected in the future. Coordinating with consultants, with training departments, with attorneys on how best to protect the company is key.
Absolutely. And again, very, very sound advice. Well, thank you, Alan, for your important time and the message and information that you've shared with us today. For those of you who are viewing this, I simply want to close off by saying that if you have any particular issue or question or situation that pertains to your organization, please contact us through the EMSI webpage, or you can contact Alan Kaplan directly through the contact information which we will make available to you. Thank you very much, Alan, and thank you for those of you who are viewing this. Thanks.
Thank you.